Spain's World Cup plans under threat as U.S. courts target state assets. U.S. courts have ruled Spain may be liable for unpaid energy arbitration awards, raising concerns over potential asset seizures during World Cup 2026 preparations in the United States. Since 2010, Spanish governments under former Prime Ministers José Luis Rodríguez Zapatero and Mariano Rajoy cut promised incentives for renewable energy investors after billions had already been committed to solar and wind projects. That decision triggered more than 50 international arbitration cases against Spain, most under the Energy Charter Treaty, ECT. So far, 27 final rulings have gone against Spain, many still unpaid. The outstanding obligations are estimated at more than 47 million euros, about $55 million, though delayed payments, interest, and fees have pushed total exposure into the billions. When a country does not comply with arbitration rulings, creditors can ask courts in other countries to seize state assets. That is where the United States enters the picture. U.S. courts say Spain waived sovereign immunity. U.S. courts have issued key rulings, including in Nextera v. Spain, concluding that Spain waived sovereign immunity when it agreed to arbitration under the ECT. As a result, U.S. courts have said arbitration awards against Spain can be enforced on American soil, including through the seizure of Spanish state assets. What can and cannot be seized? U.S. enforcement applies only to state assets, not private companies. That means Spanish corporations such as Santander, Inditex, Iberia, Telefónica, Repsol, or private businesses operating in the United States are not considered the Spanish state under U.S. law. However, courts draw a different line when it comes to public institutions. In filings reviewed by Diario AS, U.S. subpoenas have identified Spain broadly to include state ministries, public bodies, and in some interpretations, organizations such as the Royal Spanish Football Federation, RFEF, and the Spain national team. That legal framing is central to the current dispute. Why Spain's national team is now part of the discussion. Spain is currently a debtor nation. It must pay its debts, said economic analyst Diego Sánchez de la Cruz, who has followed the case closely. He argues the issue is not sporting, but legal. U.S. courts have already ruled that Spain's participation in international arbitration removes certain immunity protections, allowing enforcement actions against assets located in the United States. A key precedent cited is Nextera v. Spain, upheld by the U.S. Court of Appeals for the District of Columbia Circuit. How the national team could be affected at World Cup 2026. The concern raised by legal filings is that payments linked to Spain's national team activities in the United States could be treated as state assets. That includes revenues from friendly matches, World Cup-related reimbursements, hospitality contracts, logistics arrangements, and commercial agreements signed during U.S.-based operations. In previous enforcement actions, courts have already targeted funds linked to Spanish air navigation operator Inair in Belgium, where hundreds of millions of euros were frozen via Eurocontrol mechanisms. It is simple. Spain must pay its debts. According to Sánchez de la Cruz, enforcement is escalating internationally. He notes that Spanish arbitration-related rulings have been recognized or enforced in jurisdictions including the United Kingdom, Australia, Singapore, and the United States.